Good day to you. This week's tutorial focuses on aspects of the trustees of a scheme. It is designed for both managing agents and for trustees, and I will touch on a few common misconceptions that owners may have about trustees, issues that I suggest are worth explaining to owners. Just to give you a brief overview of where I'm going, we will deal first with representation at meetings, then on to the removal and replacement of trustees and chairpersons, and finally deal briefly with voting rights. Representation of trustees at trustees meetings. Well, I came across recently, and a few times in my career, I've come across people who believe that the issue of apologies is something completely different to what it actually is. They believe that if they can't come to a meeting, they can send in a piece of paper saying, look, these are my views, and then they expect that those views will in fact be announced, perhaps read by the chairperson, carefully considered and taken into account in the making of any decisions. Now, that is not in fact the common law of meetings in South Africa. There is no provision for apologies as a method of participation. The fact is that apologies are a noted courtesy. I can't make it. I know I'm the secretary or the treasurer or the chairperson. I can't make it to this meeting, and therefore I tell somebody else, please give my apologies. What happens is that in the minutes of the meeting, it is noted that the person wasn't able to be present, but felt bad about it, or it happened at the last minute. So it's as no more than that. It has no effect on the outcome of the meeting. The person has no voting rights as a result of their non-attendance, but their tendering of an apology. The next thing that I want to talk about is alternate trustees. A trustee who can't attend a trustee meeting isn't entitled simply to appoint a representative to replace him or her at that trustee meeting, but the trustees can appoint an alternate trustee for any trustee for this purpose. So if a trustee knows that they're going to be out of the country for some time, or for any other reason is unable to participate, they can go to the trustees, disclose this, and arrange that an alternate trustee who will represent the absent or unavailable trustee for that period is actually appointed by the other trustees. The next subject is the removal and replacement of trustees. And here I want first to look at this vote or motion of no confidence. There is a misconception that trustees and chairpersons can be removed by this process, that this is, and it's also called a censure motion, where you're not happy with the way you're behaving, so by majority vote we're going to remove you either as chairperson or trustees. Now, the fact is that a vote or a motion of no confidence is a parliamentary procedure. It has nothing to do with the way South African sectional title meetings are run. It's simply not applicable. As a matter of interest, it's a parliamentary procedure designed to bring down a government and force a general election. But it has no place in the South African law of meetings as they are applied to sectional title schemes. As a matter of background, in South African law, we do have various types of motions: main motions, subsidiary motions, procedural motions, and privilege motions. And in due course I'll unpack those. But we don't have censure motions. And so when somebody says, I want to move a vote of no confidence, no, that isn't the way it works. You can remove a chairperson, and this can be done either by the trustees who elect the chairperson or by the owners in general meeting. So the titular head of this body corporate can in fact be removed from that position, but there is a proviso, and that is that you can't do this in a bushwhacking or ambushing manner. You've got to make it absolutely clear, to specify in the notice that calls that meeting, that this subject will be dealt with. That gives the chairperson an opportunity to prepare some sort of defense. I've given you the text of PMR 19 below, from which you will see this. Then let's look at replacing a chairperson. When this is necessary, somebody resigns, or for whatever other reason, somebody is no longer available to serve as the chairperson. Well, in this case, the trustees are entitled, in terms of PMR 20, in fact they must, in terms of PMR 20, elect a new chairperson who then continues in that position for the rest of the period and has the same rights of voting. If you want to remove a trustee, then that process can only be done by a meeting of owners. At a general meeting of owners, again, notice must be given. All the same principles apply. You can't bushwhack or ambush somebody. You've got to tell them this is going to happen. Then Prescribed Management Rule 13 applies, and it's one of the ways that Prescribed Management Rule 13 sets out for somebody to stop being a trustee. So if he is removed or she is removed from office as a trustee, provided that the intention to vote on that particular item has been specified in the notice of the meeting. And what do you do once the person has been removed? Well, of course, they can be replaced, but only the owners in general meeting can replace him or her. It's not unusual to think that the trustees have the right to replace. That's not the case, not in ordinary circumstances. PMR 14 applies, and the body corporate can appoint a replacement trustee. You'll see that I've given you the text below. The co-option of trustees is something different. There's a general misconception, as I've said, that the trustees can co-opt additional trustees when they feel this is necessary. That's not the case. If you have a look at it, as we will in a second, it's an emergency procedure that the trustees are only entitled to apply when there is a situation of need, when the number of trustees fall below that necessary to form a quorum. In that case, PMR 16.2 applies, and you will see the text is on the screen again. The remaining trustee or trustees can continue to act, but only for the purpose of appointing or co-opting additional trustees. Let's move on to trustee voting rights. There is a general misconception that the chairperson has 2 votes. That's not the case. Each trustee has 1 equal deliberative vote. The issue of a casting vote, which a trustee who is elected as chairperson does have, only applies when there's an equality in the number of deliberative or ordinary votes cast. When that happens, and only in the context of trustee meetings, the person who is the chairperson has the right to break the deadlock by casting an additional vote. Thank you very much for listening to this tutorial. I hope to hear from you in the discussion forum.